Welcome back, everyone. Chille's trial starts on Monday unless he doesn't show or there's some other mishap. The judge said that Monday's date was firm. And when judges say that, they're saying there's no more continuances. So anyway, let's get to the case itself. I prepared an outline for you to show what he's really facing here. So here's the docket. I ran it today. Chille's case, misdemeanor, 2 misdemeanors. Here are the 2 offenses he's charged with. Nevada Revised Statutes right there. And this was the date the charges were brought, March 15th. You'll see that in the history here, the media requests by our Nevada judges, so they'll be covering the trial. And the bench trial is still going forward. I don't see any motions filed, so that's where we're at with that. I prepared this for our viewing pleasure as the stomach turns. So here's a Chille. And let's just go through this real briefly. NRS, Nevada Revised Statutes. That's the section resisting a public officer. And that doesn't mean resisting him because of his charm. That means resisting him because you're just not going along with the program, which, says a person who, in any case or under any circumstance, so it's all encompassing, which is why I tell you I don't like these statutes. Willfully resists. Willfully is an act of intent. It's intentional, it's not accidental. Delays or obstructs a police officer or public in discharging or attempting to discharge any legal duty of his or her office shall be punished in section 3 when there is no weapon and there wasn't misdemeanor. So some people may say that the dangerous weapon was his mouth, but I would say no, that's not what they mean by dangerous weapon. Could be bad breath. No, it doesn't mean that either. But I'm writing down there are the elements that I think that the prosecution will have to prove. Was the cop lawfully performing his duties? In other words, was he trying to detain, arrest? These are questions of fact. Did the person, in this case, Chille, know that the cop was performing his duties? Well, when a cop is in uniform, that usually satisfies it. The defendant's actions were willful, intentional. That's a question of fact. What I mean by question of fact is the judge has to evaluate it. The defendant's actions hindered, delayed, or obstructed the cop's duties. So that to me generally be the 4, obstructing a public officer. Every person who after due notice, so there has to be a lawful order, they have to know they're under notice. And it can't be a suggestion. It's got to be a due notice, like, don't do that. I'm telling you to do this. Refuses and neglects, neglects, negligence. To make or furnish any statement, report, or information lawfully required of the person by any public officer. So you could even negligently mess this up and still be charged with a criminal offense. That's why I don't like it. That's why I think the statute's too broad and I think it's too vague. Or, so alternatively, use the conjunctions. In such statement, whatever it was made, willfully make an untrue statement. Again, willfully would be intentional, misleading, or exaggerated. An exaggerated statement. And that sounds a little bit vague and a little ambiguous to me as well. What is an exaggerated statement? So I have some examples. You neglect to make a statement, you refuse to provide information, you drag it out. The Nevada case I looked at was a person just constantly makes the cop repeat himself and slows the cop down. Taunting a cop can do it just because you're distracting him and pissing him off. Going limp when arrested. So there are defenses. So Chille would have to raise his defenses. Unlawful arrest, you actually complied, the cop falsely accused you of the charge, you did not act intentionally or negligently when the statute requires it, you didn't get a lawful order, or there was an excessive unlawful force or an unlawful order. So those things would be defenses. And then the cases I've provided in my other video. That's what these statutes bother me, because you can kind of, even innocent people get swept up. We always hear this from the sovereign citizens and all the YouTube lawyers. No victim, no crime. I keep telling you, just like it is in California, you get a complaint filed against you, and it's prosecuted in the name of the state of Nevada. That's the injured party. Where's the injured party? It's the people through the district attorney. Got it? Thank you. Chille went for the bench trial. That means that we don't really have so many worrisome motions that we got to file that are pre-trial because we don't have to worry about a jury. I think it was a mistake of Chille, this is my opinion, to waive a jury trial because it's constitutional. He's a constitutional law scholar. Like he said in his video, always invoke your rights, always defend your rights, don't give them up. Why would he give up the right to a jury trial? Because they need a unanimous verdict. He just needs one guy on that jury to say no and hang the jury. And they may not retry him again on a misdemeanor. I would rather have a decision maker of 12 than a decision maker of 1 if I was facing these charges. Trial by jury. It says cases required to be tried by jury, which are all criminal cases, unless the defendant waives a jury trial in writing with the approval of the court and consent to the prosecuting attorney. Well, I didn't really see that, but maybe that happened. And then we're dealing with the Justice Court right here, which is why I copied it. This is the speedy trial constitutional requirement, which was waived repeatedly from the continuances. So what is reasonable doubt? As would govern or control a person in such a condition that they can say they feel an abiding conviction of the truth of the charge. Doubt to be reasonable must be actual, not a possibility or speculation. The court shall not allow counsel to withdraw. And by the way, lawyers just can't quit cases without approval from the client. And if the client doesn't want to consent, approval from the court. Bind and gag somebody who's disruptive in the courtroom. I think that's something to definitely to watch, you know, someone that just can't shut their mouth. And timely provide discovery. There was a notation of that on the docket that it was done because it's a constitutional right. And here's a pretrial motion. It's of course, like everything else, it's got timing conventions. It says all pretrial motions, including motions to suppress or exclude or omit evidence, those are generally called motions in limine. In limine means to exclude or to limit. Must be made in writing and served and filed not less 15 days for the date set for trial. So we looked at the docket here. We don't see any motions. For example, maybe there's, you know, if a defendant has convictions that you don't want the jury to hear, especially old felony convictions that are more than 10 years old. If you blow the deadline, then you got to give the judge a good reason to maybe allow it. So I don't see any of those. Continuances are for good cause. We've already heard the judge say, this is it. There's no more continuances. Appeals. And then he's got 10 days to file an appeal after if he's convicted, and there's another provision as well. So there's that example of a motion in limine. Now this one is pretty poorly drafted. I don't remember if it was served on me. It may have been, oh, no. It was from another defense lawyer who wanted to bring me in on a case. And I don't do motions in limine this way. What he basically did is he just took a whole bunch of them and kind of combined them into one grand consolidated motion in limine, which seems a little sloppy to me. And but this is not one that I would draft. First of all, let's just take a look at the way it's cited. In California, you do not cite cases like this. Okay. So the citation is wrong. The 1993 would go right after Jackson. And this is a generic cite, not a pin cite. A pin cite would say a comma and then the exact page where it is and a quote that says that. And, you know, the 11th Circuit is a circuit outside the 9th Circuit, so it's not binding authority. The 9th Circuit here, as written, is a federal case. Federal cases are not binding on state courts. In a nutshell, you get a good flavor of this. The burden's on the prosecution to prove that Chille's guilty. But one thing that will go, I think, heavily against Chille will be the body camera. And for all we know, the prosecutor will also bring up Chille's narration of what happened and how he said he was controlling the cop and that he had his underhooks on him and stuff like that. That to me, with these very vague statutes that are over vague, in my opinion, and if you look at the cases that I cited, and I did look at over 200 cases before I decided to make a video about it. Those cases were always in favor of police officer safety. So the main important takeaway here is that the trial court is bound by the appellate court and higher authority. And the appellate court and higher authority has always been coming down on the side of officer safety. Hope this video was helpful, and we'll see how it goes Monday. It's Friday. It's time to get out of here. But before we do, I changed into my world famous Looney Tunes tie, which you guys all liked. Got a good reception. And I just want to throw a couple of jokes your way and we go home. The first one is about an elephant on a nudist beach. As the elephant is walking along the nudist beach, he sees a man completely nude and he's looking at him, studying him. You know how intelligent elephants are. And the elephant looked at him and says, looking down, How can you possibly breathe through that thing? Man was talking to a woman and he kept insulting her, telling her how stupid she was. She didn't like that. He goes, I bet you're so dumb you don't even know what a rectum is. And she says, of course I know what a rectum is. Everybody knows what that is. He goes, really? Well, then use it in a sentence. She goes, easy. I was driving my car and I smashed into another vehicle and I wrecked him.